Good morning. Today is June 30, Friday, and we are having this class today in lieu of the class that we were scheduled to have on Monday, July 3rd, understanding now that Monday, July 3rd is a holiday that's recognized by the state. We're going to go ahead and have a conversation about what we would have had a conversation about then. That is the abstention doctrines. Due to the constitutional framework of the United States, there's a natural tension, a natural affinity for conflict that exists between our federal court system and our state court system. The majority of that is because those two systems, the federal system and the state system, share concurrent jurisdiction over many issues. And so why is there conflict? Well, we've talked about federalism throughout the course. We've talked about parity throughout the course, right? We've talked about the federal court's ability to check the state court. We've talked about Congress's ability to check the federal courts, right? It's all this very delicate balance of power. And because we have a federal system and a court system, right? We have a tiered court system. There's times where you might have the ability to go before a state court because the state court has the personal and subject matter jurisdiction, right? So the case is proper there. But the case may also be proper in the federal tribunal. Which one do you choose? Why do you choose one over the other? You might even ask, why do we have two? Well, not getting ready to get into that conversation because that's a different conversation for a different day. But with everything else being said, let's take a look at the abstention doctrines. Federal courts are sometimes asked to exercise judicial restraint. Exercise judicial restraint when it comes to extending their jurisdictional authority, right? And so federal courts may be asked to exercise judicial restraint as it relates to their jurisdictional authority in ways that don't interfere with state courts. This brings us to abstention. An abstention doctrine is a legal principle or judicial doctrine that allows a federal court, for our purposes, to decline or abstain from exercising jurisdiction over a particular case or issue that the federal court has rightful jurisdiction over in favor of deferring adjudication of the matter to another court for our purposes, namely the state court. Right. So the abstention doctrine is a doctrine that helps guide federal courts and helps federal courts understand better when are times I should not exercise our federal court jurisdiction so that the lower court can exercise their state jurisdiction. The importance of abstention doctrines lies in their ability to foster cooperative living, right? Cooperative existence. Yeah. If we can avoid unnecessary friction between the federal courts and the state courts, then we have less concern over the potential negative impact of federalism. If the federal court exercises restraint when it comes to when and how they use their jurisdictional authority, the state court can then at times play the primary tribunal when interpreting and enforcing state law, right? And that makes sense. State law, state legislators, state ideas, state values, state beliefs, yeah, state courts Makes sense. Yeah. Abstention doctrines, for the purposes of our discussion today, as I said, helps guide the federal courts, right? Because there are times when federal courts acknowledge that maybe the matter that's before the court, and while properly before the federal court, may involve such an intimately natured issue that it just might be, quote unquote, more proper for the matter to be heard and adjudicated by the state court. So in other words, the abstention doctrines help guide federal courts. Yeah. I speak about them generally. There's 4 specific abstention doctrines that you see in federal courts more often. We're only going to talk about the 2 of those 4, but before we get there, we have to get to the act that helped start the conversation, right? So let's get to the act that helped start the conversation. The Anti-Injunction Act, 28 USC, Section 2283, helped start the conversation of abstention doctrines. That's where we're going to start. Once we get the basic understanding of the Anti-Injunction Act, 28 USC, Section 2283, we're going to go to the Pullman abstention doctrine. That is the doctrine that is the result of Railroad Commission of Texas and others versus Pullman in 1941. The Pullman doctrine, we're going to go into a little bit more detail, but just as a general overview, the Pullman doctrine advises federal courts to not exercise federal court jurisdiction and allow the state court to exercise state court jurisdiction to resolve a state law that might be ambiguous or a state law where there's unsettled issues. Okay. After we look at Pullman, we're going to go to Mitchum first, and then we're going to look at Pullman. But Mitchum v. Foster is not an abstention doctrine. So why are we talking about it? Because Mitchum v. Foster is the perfect example of what we find in the language of the Anti-Injunction Act, right? It speaks about being expressly authorized. We'll get to the act just a second, it'll make sense. But when we speak to expressly authorized, what is being expressly authorized? How do we know when it's being expressly authorized? And what are we supposed to do when we see something expressly authorized? I know. I set that up with a mystery. The mystery will be resolved shortly. Our last stop on this journey today is going to be the Younger v. Harris case, which yielded the Younger abstention doctrine. We're not going to spend too much time on the actual Younger v. Harris case, because once we get into the facts, you're going to realize, oh my goodness, we've talked about this before. In fact, you've had a writing assignment that involved this case before. And so we're not going to spend a lot of time on it, but I am going to introduce the doctrine to you, because you can't leave federal courts without knowing, number one, what an abstention doctrine is. Number two, what are at least two of the four abstention doctrines and how they work. The other two abstention doctrines, right now we've talked about two. We've talked about Pullman, we've talked about Younger. The other two abstention doctrines, that's Burford and the Colorado River abstention doctrine, we're not going to discuss those, but they're there. And as lawyers, right, some of you, 1 more semester, 2 more semesters, 3 more semesters, I expect that you have that natural inquiry about yourself to want to know more about these two. So you can always find more, but for the purposes of this course and for the purposes of the final exam, we're not going to cover Burford or Colorado River. The Anti-Injunction Act, that's 28 U.S.C. Section 2283, is Congress's most comprehensive restraint on federal court interference. I'll say it again. 28 U.S.C. Section 2283 is Congress's most comprehensive restraint on federal court interference when it comes to state proceedings. This is what the act says. A court of the United States, federal court, may not grant an injunction to stay proceedings in a state court except as expressly authorized. Let me say it again. A court of the United States, federal court, may not grant an injunction to stay proceedings in a state court except where the federal court is expressly authorized to grant that injunction. Keep that in mind, because we're going to get to Mitchum. And again, Mitchum, while not an abstention doctrine, is the perfect example of the United States court, federal court, being expressly authorized. 28 U.S.C. Section 2283 states there's 3 occasions when a federal court is allowed, encouraged, expected to intervene in a state court proceeding by way of an injunction. There's 3 times. The act says the first situation where the federal court is expected to grant an injunction in a state proceeding is when Congress has expressly authorized the federal court to grant the injunction and intervene in a state proceeding. That one's really easy. If you got an act of Congress that says you can do it, do it. All right. So that's the first occasion when a federal court can intervene via injunction into a state proceeding. The second, a federal court may enjoin, right? So that means that they may issue an injunction to stop a state proceeding when it is necessary in the aid of the federal court's jurisdiction. So when's the first time the federal court can issue an injunction? When Congress expressly authorizes it. When's the second time the federal court can intervene via injunction into a state proceeding? When the federal court needs to grant that injunction in an effort to protect federal court jurisdiction. When is the third time that the federal court is authorized to issue an injunction and intervene in a state court proceeding? When that injunction is necessary to protect or effectuate a federal court judgment. Those are the 3 times. Look at the slides, make sure you understand them, because you may see that question. What are the 3 times? Again. Now, let's get to Mitchum. Mitchum is a 42 USCS section 1983 case. Mitchum says, when expressly authorized, right, the courts, federal, can intervene in a state proceeding. And an example of being expressly authorized is a 42 USCS section 1983 claim. Thank you. So what's the issue? Do 42 USC 1983 claims satisfy the expressly authorized exception, writing it as a under does when under the Anti-Injunction Act, 28 USC, Section 2283, do federal courts have expressed authorization to exercise authority to enjoin state proceedings when the defendant is seeking federal court intervention and to a state claim that's based on Section 1983. These are under does when. In the book, there's a section that talks about Mitchum v. Foster. Unfortunately, doesn't really provide a significant amount of the facts for Mitchum. So you're going to have to pull that from wherever you pull your cases. I usually go to Lexis. You can pull them from Westlaw, wherever you pull them, in order to get the facts and really get a better understanding of the essence of what's happening in Mitchum. You're not going to get that from the excerpt of the case in your course book. You're going to have to pull it. But the long story short is there's a prosecutor in Florida named Foster. The prosecutor in Florida is going after Mr. Mitchum, who is doing business as Bookmark. So Mr. Mitchum has a bookstore. The prosecutor is alleging that the bookstore is a public nuisance, and the state court prosecutor wants to close the bookstore down. So the prosecutor files suit against Mitchum, alleging that Mitchum is, or actually the bookstore that he's running is a public nuisance. Okay. Mitchum says, hold on, you are violating my First Amendment rights. The state court proceeding had already begun, right? It's already begun. Go to state court, state prosecutor puts on the case, asks for an injunction, ordering Mr. Mitchum to stop doing business. State court issues the injunction against Mr. Mitchum and says, can't do business. Not going to resolve the case today, but I'm going to issue the injunction. See you guys a month from now, 2 months from now, 3 months from now, whenever the case comes back for merits. Time goes by. Nothing's happening on the case. Time goes by. Nothing's happening on the case. There's some indication that the state prosecutor may be stalling the case. Because think about what's going on. If the state court has issued an injunction against your business, that means that you are not allowed to do business. It, in essence, shuts your business down. And if you are surviving on your business, well, it's gonna get sticky after a while because you can't conduct business because there's an injunction that prohibits you. So after some stalling, Mitchum decides to seek injunctive relief from the federal court against the injunction that's been issued against him in the state court. And in order to do that, Mitchum filed a Section 1983 claim in the federal court. Initially, the federal court receives the request for injunction to enjoin a pending state court proceeding, right? Following the Anti-Injunction Act, the federal court, district court, denied the request to grant the injunction against the state proceeding. Mitchum appealed. The federal appellate court held that the federal injunctive relief that Mitchum sought against the state proceeding was appropriate. And this is why it was appropriate. It was appropriate because the inability for Mitchum to conduct his business, part of which was a bookstore, part of which was, he argued, was First Amendment right? created and caused irreparable injury to Mitchum that the United States Supreme Court said was both great and immediate. Great and immediate. The appellate court went on to say that the state law that supported the granting of that state injunction against Mitchum was unconstitutional, flagrantly unconstitutional. The court went on to say that based upon the actions of the state prosecutor, the stalling, and etc., there was a showing of bad faith that called for equitable relief from the federal courts. Got it? I said it slow. Some of it's highlighted in red. Those are the things that you're going to need to understand how all of that works. Holding of the federal appellate court. The federal appellate court reversed the federal district court's order that denied the federal injunction that would have enjoined the state court proceeding. And the federal appellate court remanded the case back to the federal district court for further proceedings. Got it? Mitchum is the example of expressly authorized. Remember, let's just go back. I'm going to try not to go too fast so you don't lose your bearing, but let's just go back. Go back to the Anti-Injunction Act. A court of the United States, federal court, may not grant an injunction to stay a proceeding in a state court except, right, as expressly authorized by an act of Congress, or where necessary in the aid of protecting the federal court's jurisdiction, or in an effort to protect or effectuate a judgment of the federal court. So those are all three of the exceptions that allow federal courts to intervene into state proceedings. Let's take them one by one. Exception number one, which allows the federal court to intervene in a state court proceeding if the Congress expressly authorizes. Boom. Number two, this is the second exception that allows a federal court to intervene by way of an injunction, right, to a state court proceeding where it's necessary in the aid of a federal court jurisdiction. Boom. Number three, the third opportunity for a federal court to intervene in a state court proceeding is to protect or effectuate federal court judgments. Got it? Yeah? All right. So where do we go from there? We go back to exception number one under Mitchum, where Mitchum goes to state court. Mitchum alleges his constitutional right, First Amendment, is being violated. Mitchum receives the injunction from the state court. Mitchum shuts down his business based upon that injunction. Mitchum waiting to go back to court for his day in court to argue before the court, and is stalled by the state prosecutor. Mitchum then goes to the federal court and says, I need some help. I need the federal court to issue an injunction against the state court so that that proceeding can stop, so that state injunction is lifted, so that I can go on about my business, because they have violated my rights. They're continuing to violate my rights as I have pled in my 1983 complaint. Go to the federal court, district court, federal district court denies the grant of the federal injunction. The appellate court reverses and says, yes, the federal injunction is appropriate. That is an example of an expressed authorization, right? The federal appellate court said it's appropriate because the injury that was being suffered by Mr. Mitchum by way of the state injunction was irreparable, was great, and was immediate. That was enough. The court added more, said that the state law that supported the issuance of the state injunction against Mr. Mitchell was flagrantly unconstitutional. Do you see a rule building here? There's a rule building here, right? There's more. And the prosecution by the state prosecutor, based upon the actions and the conduct and the behavior, tended to show bad faith on behalf of the state prosecutor. Got it? Yeah? Boom. Conclusion. As we discussed when we talked about 1983, what is the purpose of 42 U.S.C. as 1983? The purpose, as we learned from reviewing the legislative history, some of the legislative history, the purpose was to interpose federal courts between state courts and the people. The purpose was to put the federal courts as a guardian of people's federal rights. The purpose was to protect people from unconstitutional action under color of state law. What's the conclusion? Federal injunctive relief against a state court proceeding can be done, can be authorized, is in fact encouraged in certain situations. What are those certain situations? That without the federal injunction, there's going to be immediate, great, irreparable harm to the person seeking the federal injunction. Maybe the law that is being imposed upon the one seeking the federal court injunction on the state action is flagrantly unconstitutional. We will see that that by itself is not enough, right? And if it's a 1983 claim that is asking the federal court to interfere by way of injunction, well, Mitchum has explained that that is expressly authorized. All right, sum up. Prevent great, immediate, irreparable harm. Law flagrantly unconstitutional. Showing of bad faith. Are you starting to feel like I've heard this before? I've heard this before, because this is the exact opposite analysis for Younger v. Harris. But we'll get there in a minute. Okay, got it? Moving on. 1, 2, 3. If you got questions, write them down, highlight it, come back to it. We'll discuss it on Wednesday next week when we reconvene. If you can't get through the weekend without needing to know the answer to something, email me, right? I think my email is actually up and working now. If I can get to you this weekend, I will. You know, my daughter's birthday is on the 4th of July. Text me. If I can text you back, I will. All right. Now, let's get to the actual abstention doctrines. The Pullman Abstention Doctrine is a judicial doctrine that encourages federal courts to abstain from deciding a federal constitutional issue when there are unclear or ambiguous state laws involved. Well, I thought 1983, well, this isn't a 1983 claim, right? Don't forget parity. Don't forget federalism. Don't forget the goal of the abstention doctrine is to try to breed peace, right? Is to try to prevent the unnecessary tension, okay? If there is a case where a person believes that their rights, federal constitutional rights, are being violated, do they have to exhaust state remedies? No. We know that from Monroe v. Pape. They don't have to exhaust state court remedies. They can go straight to federal court. But what you're going to see in Pullman is going to be a little bit different than what we've been seeing historically. Okay. The case that gave birth to the Pullman Doctrine is the Railroad Commission of Texas versus Pullman case, 1941. Under the Pullman Abstention Doctrine, here's the rule. Everybody wants the rule. Here's the rule. Under the Pullman Abstention Doctrine, federal courts are to consider three key elements when determining whether or not to abstain. We've got a case, we've got a plaintiff before us who's asking us for a federal injunction to, I say, intervene, technically interfere with a state court proceeding. Should we do it? Well, let's see. Number one, is this a case that involves an unclear or ambiguous state law? Is this a case where the state law provides an adequate remedy? Is this a case where if the federal courts abstain, that abstention would avoid unnecessary constitutional rulings and would instead respect the competence of the state courts? Here's the three things that I'm looking for. Because if these things exist, then the federal court is going to be encouraged. Take your hands off of it. Let the state resolve it. Here we go. Pullman doctrine is discretionary, but highly encouraged. Here's a little bit of history. I only think there's a couple of slides, but I think this helps put it in context. In our history, where trains were our primary mode of consumer transportation, they were Pullman porters. Pullman porters. Pullman porters were men who were hired to work on the railroad trains as porters. They worked in the sleeping cars. Starting shortly after the American Civil War, George Pullman sought people who needed jobs. And at the time, those people who needed jobs were former slaves. He sought those people out to work as porters in the sleeping cars for the people who were traveling on the train who had the luxury and ability to afford sleeping cars. The porter's job was to carry the passenger's bag, right? Shine their shoes, make sure they look nice and pretty, set up and maintain the sleeping berths, which, where the people slept, and serve the passengers. It's kind of like it's kind of like a personal concierge and bell person put together. Second slide for the history. I think this is the last one. Pullman porters served American railroads from the late 1860s through the 1960s. What was going on in the 1860s? 1860 to 65 was the Civil War. 1863 to 1877 was Reconstruction, right? So there are a lot of people who now had individual rights that included the right to work, the right to be paid, yeah? And so Pullman is like, I got a job for you. Here we go. Until the 1960s, when did I say that they started? They started in the late 1860s. Until the 1960s, so about 100 years, Pullman porters were exclusively Black. Okay, because we know that Mr. Pullman sought out people who had previously been enslaved and said, I can give you a job. Now, why does any of this matter? Texas is a vast and large state, even to this day. There are still parts of Texas that are not very dense with people to this day. Back in the 40s, there were definitely places where Texas just wasn't very dense, which means the population wasn't very high, which means that the passenger trains that were running through there didn't have 2, 3, 4, 5 different carts with all these people sleeping, because it just didn't have that kind of traffic. So there were places in Texas where when the train went through, there was only one sleeping cart. The policy of Pullman was, if there's only one sleeping cart, then the only employee would be the porter. If we had a train where there might be 2 or 3 sleeping carts, then the people on duty would be a porter for each of those carts, but also a Pullman conductor. Okay, Pullman conductors were exclusively white. Got it? All right. The Railroad Commission had a hearing, and the commissioner said, this is what we're going to do. If you're in Texas, if you're operating at all in Texas, your train that's coming through Texas cannot just have one sleeping cart. And if it does, then the Pullman employee must have the rank and the position of a conductor. Well, the only Pullman employee that's going to have the rank and the position of a conductor is a conductor, who are generally white. See the problem? Right? So Texas is saying, either you don't come through here, or if you come through here, doesn't matter how many sleeping carts you have in your train, you better have a conductor. Not saying you can't have a porter, but you better have a conductor. Yeah. Pullman said, Texas, I think you might be overstepping. We think that this law that has been authorized is unconstitutional. We believe that you are violating the equal rights and the due process rights of my employees. And I believe that that law is in violation of the Commerce Clause. So guess what, Texas? Meet me at the federal courthouse, because we are filing a federal lawsuit against you. And Pullman did. The porters agreed with Pullman. The porters were allowed to intervene. And the porter said, Pullman's got it right? And specifically what we care about is your violation of our 14th Amendment, right? Due process, equal protection. Yeah. The conductor said, we don't know what the commission has to say. Because the conductor said, they're not saying you can't have porters. They're saying you can't have porters without a conductor, or you can have a conductor without porters, but either way, we get to work, right? And so it's a matter of everybody's trying to earn a living. And in order to earn the living, you got to be able to work. It was filed in federal court, and the federal district court had a 3-judge panel. The 3-judge panel granted the injunction and said, Mr. Railroad Commissioner, you've overstepped. We get appealed. It gets to the United States Supreme Court, and brace yourself, because this is a little different than we've heard the Supreme Court before. The Supreme Court found, reading the Texas statutes and the Texas decisions as outsiders without special competence in Texas law, we would have little confidence in our independent judgment regarding the application of that law in the present situation. Supreme Court saying they have little confidence in their independent judgment. The response to that was, hold on a second, because the 3-judge panel that heard the case and that issued the injunction against the Texas commissioner, one of the judges was able and experienced and worked that circuit as an able and experienced justice, right? In the circuit that included Texas. So that justice was familiar with Texas. In addition, the other 2 district justices were trained in Texas law. So the panel was well competent in Texas law, the ability to understand it, the ability to apply it, the ability to interpret it. The United States Supreme Court said, nonetheless, the last word on the meaning of Article 6445 of the Texas Civil Statutes, which is the law that said we want a conductor, right? The United States Supreme Court found that any interpretation of that doesn't belong to the Supreme Court of the United States. It doesn't belong to the Federal Court of the United States. It belonged to the Supreme Court of Texas. The Supreme Court went on to find that in this situation, a federal court of equity is asked to decide an issue by making a tentative answer, which may be displaced tomorrow by state adjudication. This is the Supreme Court of the United States talking. They finally find that the reign of law is hardly promoted if any unnecessary ruling of a federal court is supplanted by the controlling decision of a state court. Ultimately, the Supreme Court held in Railroad Commission of Texas v. Pullman to remand the case to the district court, federal court, who had issued the federal injunction, with directions to retain the bill pending a determination of proceedings to be brought with reasonable promptness in the state court in conformity with the opinion. There was a federal question. It was filed with federal question jurisdiction in the federal court, and the United States Supreme Court kicked it to the state court. That's very different than what we've seen thus far. So this is what the Pullman Abstention Doctrine stands for. If it is a state case that is creating a federal constitutional issue because the state law in question is unclear or the state law in question is ambiguous, the federal court needs to back off and let the state court work it out. Part of the reason, if the state court can bring clarity to the state law, or if the state court can remove the ambiguity of the state law, maybe the federal constitutional issue is resolved. Everybody's happy. I pause. What do you think about that? Here we go. Under the Pullman Abstention Doctrine, federal courts consider 3 key elements when they're trying to determine whether or not to abstain. 1, is there a constitutional question involved? And if it is a constitutional question, is it because there's a state law that's unclear or a state law that's ambiguous? Number 2, is there an adequate state remedy, right? The state law must provide an adequate and independent remedy. Number 3, hadn't heard this one before, avoidance of constitutional adjudication. The abstention doctrine is invoked to avoid unnecessary constitutional rulings by the federal court while respecting the competence of state courts. Questions? Think about it, write them down, read the case, pull the full case, read the analysis, work with it, massage with it, try to figure it out. If you still have a question, let's talk about it on Wednesday. Let's move on to the Younger Abstention Doctrine. The Younger Abstention Doctrine is a judicial doctrine that stems from the landmark case, Younger v. Harris. We've talked about it before. The Younger Abstention Doctrine establishes a general principle that federal courts should abstain from interfering with ongoing state criminal proceedings. Ongoing state criminal proceedings. Sound familiar? Hold on, you'll recognize it soon if you don't recognize it already. The Younger Abstention Doctrine recognizes that the state's interest in enforcing its criminal laws should take precedence over federal court intervention, right? It's a state criminal case that's already started. Let the state resolve it, right? Under Younger, federal courts are required, it's not discretionary, federal courts are required to abstain from hearing cases in three main situations. What's the three main situations? One, ongoing state criminal proceeding. If it's an ongoing state criminal proceeding, the federal court generally must abstain and allow the state court to continue their proceedings. State civil enforcement proceeding. The Younger Abstention Doctrine also applies to state civil enforcement proceeding. If the state is pursuing a civil enforcement action that is quasi-criminal in nature, stop. Let them work it out. Adequate and available state remedies. For the Younger Abstention Doctrine to apply, there must be an opportunity for the federal court litigant, that's the one who's seeking federal court intervention, to raise a federal constitutional claim if there's adequate state remedies. So if you have a federal constitutional claim, but you are in the midst of a state criminal proceeding, then you are required to make that federal claim, because concurrent jurisdiction, you can, right? But you are required to make that you violated my federal constitutional rights claim in your state court proceeding. And if you do, because you got to do that first, right? But if there's adequate and available state remedies, federal court's out. Federal court's out. Okay. Now, there's some exceptions, because with every rule, there's an exception. What are the exceptions for Younger? Federal courts may intervene when there's a showing of bad faith prosecution. Mitchum. When a patently unconstitutional law, that flagrant unconstitutional, is present, that's Mitchum. When irreparable harm would occur if abstention were enforced, that's Mitchum. Irreparable harm would occur, right? And remember the Mitchum case, the court said that the harm was not only irreparable, but it was great and it was immediate. Got it? Now, if that's going on, then the federal court can issue the injunction in a pending criminal case. What is the Younger Abstention Doctrine doing? What the other abstention doctrines are doing, trying to strike a balance between protecting federal rights of the people and respecting the proper role of state courts. Got it? We know that the importance and significance, federalism, respecting state sovereignty, preventing the interference in state proceedings, trying to build judicial harmony, right? Real brief facts. Younger was indicted on criminal charges in California. The criminal proceeding had begun. Younger was saying, you are violating my constitutional rights, but the criminal proceedings had begun. Younger wanted the federal court to get involved and ask the federal court for an injunction. Stop. Younger did not seek 28 USC 1441 removal. He sought a federal injunction, asking the federal injunction to stop the state court proceedings, right? He did allege violation of his First and 14th Amendment rights. He did not file a 1983 claim, okay? 3-judge panel heard Younger's request. They issued it. The United States Supreme Court reversed it. The United States Supreme Court reversed it and said, look, guys, the unconstitutionality of a state statute on a space is not enough. And we're not saying that this statute is unconstitutional, but let's be real clear so you're not getting things mixed up with Mitchum. That by itself is not enough. State court proceedings in the Younger case, the court found, had been brought in good faith. Younger had the opportunity to address the allegation of federal constitutional violations in the state court, so that was available to him. The only injury that Younger is faced with is all connected to the criminal proceeding, none of which is immediate, irreparable, right? The United States Supreme Court said that the district court's injunction, federal district court's injunction on the state criminal proceeding was a violation of federal policy that forbade federal courts from getting involved in state criminal proceedings that had already begun, right? No irreparable great harm. There is adequate relief by state law, and there just wasn't a reason to be there. That is the end of our abstention lecture. What are you going to see on the final exam? You're going to see questions about Pullman. You're going to see questions about Younger. And you're probably going to see questions about the general abstention statute, which is the Anti-Injunction Act, 28 USC section 2283. That is the end of our week. We will not meet on Monday, July 3rd, because it's a state holiday. We will not meet on Tuesday, July 4th, because the world shuts down to celebrate my daughter's birthday. Happy 4th of July. We will meet by Zoom on Wednesday and Thursday. Those are reviews. So bring your questions, but when you bring your question, be able to explain what you've done to try to resolve the question before you asked. Have a great long holiday. Be safe, be smart, and be safe. I look forward to hearing from you guys or seeing you guys on Zoom on Wednesday. Thank you.